All rise. Superior Court of the State of California, County of San Mateo, Department 119 is now in session. Judge Sucre presiding. Please be seated and come to order. Turn off all cell phones and refrain from talking.
Get started. We can go right into introductions. So I see the microphone is already handed. So the prosecution, would you like to introduce yourself?
Good evening, Your Honor. My name is Bronwyn Pigeon, and tonight I will be arguing the pretrial motion on behalf of the people of the state of California.
There we go.
Oh, may my co-counsel please introduce themselves?
Yes.
Good evening, Your Honor. Jolie Gergius for the people of the state of California.
Good evening, Your Honor. Maggie Blanchard for the people of the state of California.
Good evening, Your Honor. Anna Metwelly for the people of the state of California. And with the court's permission, may our witnesses please introduce themselves?
Yes, they may.
Good evening, Your Honor. My name is Megan Gomez, and tonight I am Detective Dylan Mavis.
Good evening, Your Honor. My name is Patron Savage, and tonight I am Cleo Schaefer.
Good evening, Your Honor. My name is Alexis Tom, and tonight I am Ari Couch.
Good evening, Your Honor. My name is Anna Fox, and tonight I am Billy Scher.
Defense?
Good evening, Your Honor. My name is Charlotte Sullivan, and tonight I will be arguing the defense pretrial motion on behalf of the defendant and Team D. At this time, may my co-counsel please introduce themselves?
Yes, they may.
Good evening, Your Honor. Avery Jones representing Jordan Franks.
Good evening, Your Honor. Catherine Moorhead representing Jordan Franks.
Good evening, Your Honor. Amelia Gazard representing Jordan Franks. With the court's permission, may our witnesses introduce themselves?
Yes, of course.
Good evening, Your Honor. My name is Anna Street, and tonight I am Jade Marquez.
Good evening, Your Honor. My name is Frankie Thompson, and this evening I'm Ezra Weintraub.
Good evening, Your Honor. My name is Elise McBride, and tonight I am Carter Lucky.
Good evening, Your Honor. My name is Ilaria Delabate, and tonight I am Jordan Franks. With the court's permission, may our bailiff please introduce herself?
She may.
Good evening, Your Honor. My name is Alondra Ordonez, and I am your bailiff for this evening. Would you like me to explain the rules of the court?
Yes, please.
All cell phones must be turned off or put on silent. If you must take a phone call, please exit the courtroom as quietly as possible in between the testimony of the witnesses. No food or drinks are allowed with the exception of water.
Thank you, bailiff. It seems that all parties are present for People v. Jordan Franks. Tonight, Jordan Franks has been charged with larceny, battery causing serious bodily injury, and robbery. Before we proceed to the trial, I understand that the defense has filed a motion to exclude evidence. Is the defense ready to make an argument on that motion?
Yes, Your Honor. And once more, for scoring purposes, my name is Charlotte Sullivan. Good evening, Your Honor, and may it please the court, defense moves that Exhibit A and all evidence pertaining to it be excluded from the trial as it violates the defendant, Jordan Franks' Fourth Amendment rights. When we talk about consent in terms of the Fourth Amendment, what we're really talking about is a choice. A true choice that a person has in allowing the powers of the state to search and seize their personal and private property. And in Ms. Franks' case, this choice was taken away as Detective Mavis blocked her only exit, threatened her with a warrant, and then lied about the very warrant they were threatening her with. Due to the yes, Your Honor?
Oh, well, I was just going to ask you, what standard are we holding these choices to?
We are holding these standards to the Sneckloth v. Bustamante case, in which it outlines the totality of these circumstances.
And now with the totality of the circumstances, I know we're talking about them, but are all of these circumstances equally important, or should I weigh some more than others?
Not all circumstances are equally important. For example, in Bumper v. North Carolina, a Supreme Court case, Simply an officer claiming they have a warrant when they do not negates any form of consent given. As when an officer of the law claims they have power under a warrant, they are claiming, in effect, the occupant has no right to resist the search, taking away that true choice. To continue on with the totality of the circumstances, we turn to Los Angeles v. Castaneda. And in Castaneda, it states that the way a defendant feels and views a situation is imperative to determining if it is coercive. And from our defendant, Jordan Frank's point of view, an officer of the law had moved to block her only exit in an already small room just moments after she refused him his ask and request to open her personal and private property. He then threatened her with a warrant, stating it was being authorized. She goes as far as to say that she was scared of the detective's attitude, talking to her as if she was a criminal. These are not the words of someone who feels comfortable and safe and like they have a choice. She felt powerless. And under Castaneda v. Los Angeles, it makes it abundantly clear that we must take this into consideration. Finally, the statement, a warrant was being authorized, is a blatant lie when looked at the facts of the situation. Detective Mavis said this to Miss Franks, and yet at the time of stating this, he hadn't even submitted it yet. And yet here he was, claiming it was being authorized as if it was already on the magistrate's desk being stamped for approval. And Miss Franks believed it. She truly believed that a warrant was on its way, and she had no choice. And so she moved aside and opened the safe.
So it is your position that Detective Mavis lied?
Yes, Your Honor.
And does it even matter whether it was truth or a lie or a mistaken assumption?
It does not matter, Your Honor, as under Bumper v. North Carolina, we have no reason to know if the officers were blatantly lying or it was simply a misunderstanding. However, they still held that it was unconstitutional. Miss Franks believed she had no power and that no matter what she said, that it would be overturned as a warrant was coming. And so she moved aside. This is called resigned inevitability. And under Bumper v. North Carolina, it is strictly prohibited and makes any form of consent, verbal or nonverbal, invalid. Due to the totality of these circumstances, as well as the liability of the warrant being claimed when it was not truly there yet, the defense asks that respectfully requests that you deny Exhibit A from going into evidence for the preceding trial.
Thank you, defense. Would the people like to respond to the defense's motion?
We would.
Proceed.
Okay. Good evening, Your Honor. The prosecution respectfully requests that you deny the defense's motion and include Exhibit A in the preceding trial. The evidence pertained under Exhibit A was obtained well within the bounds of the Constitution and precedent case law. If we look further at the situation at hand, we see that the detective was never coercive and that the defendant was well within all of their rights. Now, to understand whether or not a situation is or is not considered coercive, we would use the totality of the circumstances test as outlined under Schneckloth v. Bustamante. These circumstances can be anything from age to level of education to number of officers. It can be anything.
In this case, which circumstances do you think are the most important?
So again, there are an infinite number of circumstances in this case, as there are in all cases. However, the two, I think, what is most important that we focus on tonight are Detective Mavis's positioning in the cabin and their mention of a warrant to the defendant.
Thank you.
Okay, so if we look at that first factor, Detective Mavis was standing in a way that the defense claims was coercive, as they were blocking the defendant's only exit. However, they weren't actually being coercive. Their other options were to continue standing directly over the defendant, where they were standing at that moment, or to maybe step outside, where they would no longer be able to see the defendant, and the defendant could potentially tamper with important evidence, or they could walk farther into the room. And while the defendant had given them consent to go farther into the room, it would have seen as a further breach of privacy, and the detective would have wanted to give the defendant as much privacy as they could while still obtaining the evidence they needed.
Yes, and despite the detective's feelings, obviously, about their positioning, the defendant claimed in her statement that she didn't feel she could say no to the detective, and that she was coerced and scared by them. So isn't that like the Castaneda case in which the defendant felt virtually powerless?
Okay, so the thing is that the defendant in the case never showed any signs of coercion that the detective picked up on. They never verbalized that they were feeling coerced. They never even made any nonverbal or unconscious signs that they were feeling under pressure. And the detective is someone who is well trained in these situations. They've been working for 12 years. They probably would have learned to pick up on signs like that. However, they didn't. And in those cases, and in their statement, again, this is someone who was trained for 12 years to give statements like these, they never said that the defendant seemed remotely coerced, and the defendant only gave their statement while they were in custody, waiting trial, when they would have had every motivation to say they were feeling coerced.
Thank you.
Now, the second factor we should be looking at is the detective's mention of a warrant. The defense claims that under Bumper v. North Carolina, the detective was lying about a warrant that they did not have, and thus this case that the defendant was subject to resigned inevitability, and this was an unconstitutional search. However, they weren't. Under People v. McClure, an officer can say that if they can obtain a warrant in the future to a defendant or a suspect if they have a good faith belief that they can. Now, Detective Mavis had already filled out the form and stated in their statement that they had a good faith that they believed they could get a warrant within 24 hours. This is not something you do if you do not think you can get a warrant. Not to mention the fact that we don't actually know if they had or had not submitted the warrant. They just said they had filled out the form and they expected to get it in the next 24 hours. That does not mean they did or did not submit it. It could be on the magistrate's desk at that moment. But even if it wasn't, getting a warrant authorized is a long and complicated process. And the detective was simply condensing it into some simpler words that the defendant would have understood, because they probably wouldn't have more than a base level understanding of the law. Now,
I see what you're saying, and what about in U.S. versus Hicks, though, and which the police says that the police that the police can't threaten to get a warrant can't threaten to get a warrant in order to obtain consent. So is that what happened in this case?
No, it wasn't. As I just said, there is the detective was simply stating a fact they believed to be true. They had a good faith belief that they would have a warrant authorized within the next 24 hours. And they've shown that by filling out that form and stating that in their statement. And they were simply informing the defendant of that. That was not a threat. That was not that they were going, and not them saying that they would take action if the defendant did not consent then. It was saying that this is action I have already taken, and the consequences of that action will simply be coming through soon.
So the good faith belief takes away from it being.
Yes. Yes. So, Your Honor, if we look at both of these factors, we see that all of the defense's arguments are simply untrue, and that the detective never violated anything laid out by both the United States Constitution and precedent case law. Both they and their actions with the defendant were well within the bounds of the law, and because of this, the prosecution respectfully requests that you deny the defense's motion and include Exhibit A in the preceding trial.
Thank you, counsel, for your arguments. Would you have a rebuttal prepared?
Yes, Your Honor. For starters, opposing counsel brought up that the officer merely stood at the door to give them space. However, in Detective Mavis's own statement, they say, "I moved and stood in the doorway in order to give Ms. Franks more space to open the safe." Yet, they did this the moment after she said no. Why would they move to the doorway to let the defendant open a safe that they just said they weren't going to open. Next, opposing counsel says that my defendant, Ms. Franks, said never seemed uncomfortable or coerced, yet they said no. They showed they were uncomfortable with the idea that the officer looking in their safe by simply saying no.
And on that point, I know that there are some factual disputes between Detective Mavis's testimony regarding how many times consent was asked and how many times no was said in the defendant's own testimony. So in your opinion, how can I or should I try to evaluate these two different stories?
Well, quite frankly, it doesn't matter how many times the question was asked, as one no should have been enough. Next, they mentioned if the officer has a good faith belief they can get a warrant, it is not a threat, it is simply a declaration of legal remedies. However, Detective Mavis did not say that they could get a warrant, that they would get a warrant. They said it was being authorized. And is this difference between McClure and our case in wording that defines truth from a lie? And finally, Your Honor, they said that we do not know if the warrant was submitted yet or not. But in Detective Mavis's own statement, he says, I prepared a warrant to submit to the magistrate. They never said they submitted it. They said they planned to submit it. If they had, they would have said so. For these reasons that I have provided for you today, defense respectfully requests you grant our motion to suppress Exhibit A.
All right. Good evening, Your Honor. Defense has made several points which we would like to rebut. So the defense states that the defendant's subjective opinion is paramount. However, what Castaneda v. Los Angeles actually says is that it is a factor. It is something which must be considered. It is one factor in the case. And so as much as we must consider it one factor in the case, there are several other factors in this case, as we have already discussed. Now, they also mentioned that because they were saying that the warrant was being authorized, it was a threat. However, as we have stated before, the detective stated that they prepared a warrant to submit and expected it to be authorized within the next 24 hours. They believed within 24 hours they would have an authorized warrant to search that safe. Now, the detective was again just stating fact with that. We don't actually know if the detective ever submitted that warrant. They said they prepared to submit it and that they expected it to be authorized within the next 24 hours. Those statements do not say if the detective did or did not submit the warrant. So you cannot argue either way. Now, this means that whether or not the detective did in fact submit that warrant, they believed they would have an authorized warrant, and they believed they would have it immediately. And again, they were simply simplifying a very complicated process for someone who wouldn't understand the intricacies of the law in the United States legal system. So they were not doing anything coercive. The defendant was well within their rights, and so all evidence pertained under Exhibit A was obtained well within the bounds of the Constitution and precedent case law. Because of this, Your Honor, the prosecution respectfully requests that you deny the defense's motion and allow Exhibit A into the proceeding trial.
Thank you, prosecution. All right, so thank you, counsel, for both of your arguments. I just want to be clear that my ruling will not reflect how well either side was argued. You both argued extremely well, but it is just what I understand the law to be. So in this case, while the people have the burden to prove that someone giving consent to search does so freely and voluntarily, past cases have allowed for a lot of circumstances in which consent was still considered voluntary. The main exception, of course, is that the police cannot lie about the existence of a warrant, which I believe you did bring up. But the record here is unclear as to whether Detective Mavis actually applied for a warrant or not. So for this reason, as technical As it may be, I'm going to deny the defense's motion and allow Exhibit A at trial. So now if counsel needs a moment to rearrange yourselves for the beginning of trial, please feel free to do so. Perfect. Okay, welcome back, everyone. We've done preliminary matters pre-trial now. We are at opening statements now. So are the people ready to make their opening statement?
Yes, Your Honor.
Perfect. Please proceed.
An intense confrontation, a broken arm, a stolen. It almost sounds like something out of Shakespeare. Yet, for Billy Sure, it became a grim reality. One tragic. An act of violence. And I think Jordan Frank stole both a ring and a roll from Billy Sure. A night where envy met opportunity. Like any other powerful emotion, envy grows stronger with time. Tonight, you will hear from four witnesses who will prove that the defendant, Jordan Franks' envy, had been growing since the first time they met fellow actress and the victim, Billy Sure. As Cleo Schaefer, a friend and mentor of the victim, will testify, Ms. Sure was constantly subjected to hostility at the hands of the defendant, which stemmed from Ms. Franks' resentment of Ms. Sure's success. We will show that this underlying envy finally bubbled over the day that Ms. Sure was given the lead role in an upcoming Broadway production, the role that Ms. Franks had so coveted. We will prove that this was the catalyst that transformed Ms. Franks' envy into action. However, it wasn't just this casting decision that pushed Ms. Franks over the edge, because a special opportunity presented itself to the defendant that night. Ms. Sure will testify to how, unlike usual, she left her prize ring unprotected on the dresser in the room she shared with the defendant. What was so special about this ring is none other than William Shakespeare's original signet ring, worth $170,000, as Ari Couch, a certified jewelry appraiser, will authenticate. Ms. Franks took the rare opportunity of this valuable ring being left vulnerable to steal it, getting back at Ms. Sure for her years of successes. Ms. Sure will tell the court how she walked in right as Ms. Franks was stealing the ring, leading the defendant to violently shove her. This resulted in Ms. Sure breaking her arm, conveniently leaving her lead role to her understudy, the defendant. The events of that night will be corroborated by Detective Dylan Mavis, who will describe the investigation as logical, proper, and efficient. Your Honor, throughout the course of this trial, I ask that you look for the answers to three questions. Was the ring taken from Ms. Sure without her consent? Was this ring valued at over $950? And was force willfully used in order to steal the ring? Tonight, the prosecution will prove that the answer to all of these questions is a resounding yes, therefore meeting our burden of proof beyond a reasonable doubt for all elements under Calhoun's 925, 1600, and 1800. Your Honor, by the time my colleagues, Ms. Burgess and Ms. Metwally and I have rested our case, it will be clear to this court how far Jordan Franks was willing to go on that night where envy met opportunity. And therefore, we will ask for a verdict of guilty of the charges of robbery and battery causing serious bodily injury. However, should you find the defendant not guilty of robbery and battery, we ask that you find him guilty of grand theft larceny, with a lesser-related offense of petty larceny. And after hearing the evidence tonight, I am confident that you will return with a guilty verdict. Thank you.
Prosecution. Now, would defense like to make their opening statement now or wait until the people have rested?
Now. Tonight, Jordan Franks is on trial not because the evidence found, but because the evidence left unexplored. The prosecution will have you believe that Jordan Franks was guilty of robbery, larceny, and battery. However, the evidence tonight will show you how the prosecution has at every turn and with every witness sped past the truth and rushed to judgment. Under Calcrim Section 1600 and 1800, the prosecution must prove beyond a reasonable doubt that Ms. Franks stole the ring belonging to Billy Sure. But Ms. Franks will testify that she didn't even see the ring that night.
Under Calcrim Section 925, the prosecution must also prove beyond a reasonable doubt that Ms. Franks willfully harmed Billy Schur. However, they cannot prove this because several key eyewitnesses will testify that Ms. Schur broke their arm in an accident. The entirety of the state's case relies on evidence that is neither substantiated nor individual. You will hear that Detective Mavis's investigation was linear, short-sighted, and not thoroughly completed. You'll hear that Mavis heard only Schur's amount of the events before investigating, Ms. Franks as the primary and only suspect. You will hear Billy Schur speculate and assume that Ms. Franks was incredibly envious of them. You will hear Cleo Schaefer forfeit all her pretense of objectivity. And R. Couch's numerous claims regarding the ring's authenticity will be proven largely groundless and uncorroborated. So, what happens when we actually search for the truth? Ms. Franks will not lie that she likes Schur or that she likes being their understudy. However, that alone will not be enough to prove that she committed the crimes she has been charged with. Jade Marquez, the esteemed jewelry appraiser, will tell you how the signet ring was most likely from the Elizabethan era. Ezra Weintraub, the head of security, will explain how the camera system works and how the numerous cast members, not just Franks, had access to and entered the dressing room that evening. Most significantly, Carter Lucky will testify to being in the exact places as Franks most of the night, usually in the exact same time and disappearing for half an hour. Tonight, my co-counsel, Ms. Moorhead and Ms. Gazzard, and I asked to look at the truth that the people have sped past and make your own judgment, instead of taking the state's rushed ones at face value. Once all evidence is presented, it will be clear that the prosecution had failed to fulfill their burden of proof, and that the defense will ask that you find Ms. Jordan Franks not guilty on all charges. Thank you.
Thank you, defense. All right, we can now proceed with testimonies. Does the prosecution have any witnesses on the stand?
Yes. Good evening, Your Honor. The prosecution calls Detective Dylan Mavis to the stand.
Detective Dylan Mavis, please approach the stand. Please raise your right hand. Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the Moscow Constitution? I do. You may proceed.
Good evening. Please state your name and occupation for the court.
Good evening. My name is Dylan Mavis, and I'm the lead detective with the Portsmouth Police Department.
And how long have you been working with the department?
This is my 12th year with the department.
How are you involved in the case at hand, if at all?
I was the investigating officer in this case, arriving at the Heart of the Ocean shift at approximately 1 a.m. Paramedics arrived roughly around the same time.
Detective, do you know Jordan Franks?
Not personally, ma'am, but I did meet her over the course of my investigation.
Is Jordan Franks in the courtroom today?
Yes, ma'am.
Would you please identify them by their physical appearance?
Yes, she currently has her hair in a bun along with a navy blazer and a white blouse.
Thank you. Detective, what was your first course of action after arriving on the heart of the ship Ocean?
I located Miss Schur in a cabin on a crew deck, and she appeared to be in substantial pain.
What information did Miss Schur provide you with?
I learned that Miss Schur had witnessed her roommate, Jordan Franks, attempting to take a ring box and its contents outside of their shared cabin without her permission. The defendant then became violent, and that's how Miss Schur's arm came to be injured.
What was your next course of action after speaking with Miss Schur?
I spoke with another passenger aboard the ship by the name of Carter Lucky.
And what information did Carter Lucky provide you with?
I learned of the contentious history between Miss Schur and the defendant. It was also brought to my attention that I should speak with another passenger aboard the ship by the name of Cleo Schaefer.
Did you speak with Miss Schaefer?
Yes, ma'am.
And what information did Miss Schaefer provide you with?
I learned of further information regarding the ring, and also learned of further corroboration towards the defendant's supposed animosity towards Miss Schur.
Did Miss Schaefer provide you with any further information?
Yes, ma'am. It was brought to my attention that Jordan Franks was last seen in the Blue Diamond Cafe. I went to the location. I did find Jordan Franks there, but also something else.
What else did you find?
In a nearby trash can, I spotted a black object. I then further investigated and it appeared to be a black velvet ring box. I then bagged it as evidence and walked over to speak to Jordan Franks.
Your Honor, permission to approach the exhibits? Detective, do you recognize Exhibit C?
Yes, ma'am.
What is it?
It is a photograph of the object I found in the trash can.
Is this a fair and accurate depiction of the object you found inside the trash can?
Yes, ma'am.
Your Honor, I ask that this item be moved into evidence as Exhibit C.
Does the defense have any objections to this?
Yes, Your Honor. Should I just walk over now? Wait, what? Wait. Can you repeat what your question was?
Oh, yes. Does the defense have any objections to the addition of Exhibit C as evidence?
Okay.
None, Your Honor.
I lost it.
May I please continue with my examination? Did you speak with Jordan Franks?
Yes, I asked her if they had recognized the object. She identified to me as the ring box that Miss Sure typically has her ring in.
Did you go anywhere else after interviewing Miss Franks?
I accompanied Franks back to her cabin, where I did a further investigation and further interviewed her.
And what did you find inside the cabin?
I found some evidence in a safe in the cabin's closet.
Did you further investigate the safe?
Yes, ma'am. In it, I found some irrelevant medical documents along with a piece of paper with a few notations.
Your Honor, permission to approach the exhibits? Detective, do you recognize Exhibit A?
Yes, ma'am.
What is it?
It is a photograph of the note I found in the safe.
Is this a fair and accurate depiction of the note you found within the safe?
Yes, ma'am.
Your Honor, I ask that this item be moved into evidence as Exhibit A.
Does the defense have any objections?
None, Your Honor.
All right, it's so moved.
Thank you. Where else did you go after investigating the safe?
Seeing as how both Miss Sure and Miss Franks were actors aboard the ship, I decided to search the cast dressing room.
And what did you find inside the cast dressing room?
In the dressing room, inside of a coat pocket, I found the signet ring. The coat was hanging outside of an empty locker.
Your Honor, permission to approach exhibits? Detective, do you recognize Exhibit B?
Yes, ma'am.
What is it?
It is a photograph of the signet ring.
Is this a fair and accurate depiction of the signet ring?
Yes, ma'am.
Your Honor, I ask that this item be moved into evidence as Exhibit B.
Does the defense have any objections?
None, Your Honor.
All right, so moved.
Thank you. Detective, did you find any evidence of who went into the dressing room that night?
I spoke with the head of ship security, Ezra Weintraub. She explained that there was no longer footage of the night in question, but she had distinctly remembered Jordan Franks enter the dressing room at a point that evening.
What did you do after this?
I returned to Frank's cabin to ask about the coat. Franks then identified the coat to me as a part of her costume.
What occurred on June 10th, 2022?
Based on the evidence I had collected regarding the altercation, the ring box itself was found near Frank's, and the ring itself was found in Frank's costume. I obtained an arrest warrant for robbery and battery and arrested Jordan Franks on June 10, 2022 at 8 a.m.
Thank you, Your Honor. I have no further questions for Detective Dylan Mavis at this time.
Prosecution. Cross?
Yes, Your Honor. Okay. Detective Mavis, you arrived on the scene of the crime at approximately 1 a.m., is that right?
That's correct.
And you received an arrest warrant for Jordan Franks the morning at 8 a.m., correct?
Based on the evidence I had collected, yes.
So, Detective Mavis, it only took you 7 hours to conduct your full investigation. Is that correct?
It took me 7 hours to find all the necessary evidence for the case, yes.
Upon arriving on the scene, your first action was speaking to Cher, correct?
Well, she was the one who called, so I assumed that it was necessary.
And right away, Cher, quote unquote, pointed the finger at Jordan Franks. Is that right?
I guess you could say so in a way, yes.
You reported that Franks was seen at the Blue Diamond Cafe that night of the June 9th, correct?
That was what I was told, yes.
And you found that Franks was also in the dressing room where the ring was found, correct?
That was the information I collected, yes.
You then questioned Franks about the ring box. Is that correct?
That is correct.
You escorted Franks to her room. Is that correct?
Yes, to further interview her and investigate her cabin.
You then told her not to leave the room?
Yes.
You asked Franks for consent to search her room, correct?
Yes.
You also searched her safe, is that correct?
I deemed it necessary, yes.
Ms. Scher told you Carter Lucky was also present during the confrontation with Ms. Franks, didn't she?
That's what I was told, yes.
And you also found that Carter Lucky was seen in the dressing room that evening, right?
That's what I was told once again, yes.
And you also learned that there were 30 minutes where Carter Lucky's whereabouts were unsubstantiated, is that right?
I was made aware of that, yes.
And Ms. Scher told you that both Ms. Franks and Ms. Lucky appeared to be jealous of Ms. Scher at times, correct?
I guess it could be resumed in such a way, yes.
Ms. Lucky even said in their statement that they were out of work and needed money, is that right?
Yes, but I do not see how it's necessary.
Yet you didn't question Ms. Lucky about the ring box, correct?
That's correct.
You never told Ms. Lucky not to leave her room, correct?
I did not deem it necessary to do so.
You also didn't search her room, correct?
Once again, I did not deem it necessary to do so.
All you did with Ms. Lucky was speak to her, correct?
Yes.
Okay. No further questions. Thank you, Your Honor.
Your Honor, may this witness please be excused?
Yes, you may.
Yes. At this time, we would like to call Cleo Schaefer to the stand.
Cleo Schaefer, first stand. Please raise your right hand. Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the Marshall Constitution? I do. You may begin.
Good evening.
Good evening.
Please state your name and occupation for the court.
My name is Cleo Schaefer, and I am blissfully retired.
What do you do in your free time?
Well, being 76 years young and loving cruises almost as much as I love theater, I decided to invest in my favorite play on my favorite ship, which led to Macbeth at Sea on Heart of the Ocean.
And do you know Billy Scher?
Why, of course. I met Billy's grandmother way back in college. I think it was when Broadway was still narrow. Anyways, so I've known Billy for ages. But despite this, Billy and I have grown even closer as she starred in Macbeth at Sea.
And what do you think of Billy's performance on the ship?
I truly think she's done such a fantastic job in this role. I admire how she's handled the obstacles she's had to face on board.
And what do you mean by obstacles?
The hostility. I mean, she's been continuously insulted and ridiculed on multiple occasions. And that Jordan is the worst of them, saying that she received special treatment, doesn't deserve the lead roles, or the ring. I mean, there's jealousy, and then there's outright hostility.
Now, moving on to the night of June 9th, where were you that evening?
Well, that was the closing night of Macbeth at Sea. And anyone who knows me will tell you that I don't let my old age stop me from having a good time. So naturally, I decided to commemorate our last show by hosting a wrap party for the cast and crew in the Midnight Lounge.
And to your knowledge, did the defendant attend this party?
Yes, ma'am. I saw him there.
And did anything of note happen while at the party?
Actually, yes. While there, I happened to overhear Jordan say something that struck me as a little odd. Jordan said, "I can't believe they give this sword to Scher. If Scher breaks a leg or something, then they'd at least someone competent to take over."
And at about what time would you say you left the party?
I returned to my room around 10:45.
Did you stay there for the remainder of the night?
Oh gosh, I'll admit, this old bird got a little peckish and decided to indulge in a midnight snack in the Blue Diamond Cafe.
And did anything of note happen while on this excursion?
Actually, yes. While there, I happened to see Jordan. They were throwing something away near the ice cream machine. Then they walked over to Carter and seemed to become engaged in a deep conversation. So I didn't end up speaking to them.
Thank you, Ms. Schaefer. No further questions, Your Honor.
Good evening.
Good evening.
Let's talk about your connection to the Scher family. You went to performing arts school with Mick Scher's grandmother, didn't you?
I did, and that was some time ago.
That family connection is part of the reason you're so close to Mick Scher, isn't it?
Well, that's part of it. It's mainly because of his acting talent, and I also have spent a long time with him throughout the show.
You're so close to Mick Scher that you gave them a family heirloom signet ring, right?
Well, I don't have any heirs of my own, so
Yes.
In fact, you stated that Billy Sure was like your child, didn't you?
Like I said, I don't have any heirs of my own.
But you never considered Miss Franks as your own child, did you?
Well, I haven't known Miss Franks as long as I've known Billy.
So you didn't consider Miss Franks as your own child?
I can't say that I did.
You never gave Miss Franks a signet ring?
I didn't have another ring to give.
You don't have any family connections with the Franks family, do you?
I do not.
You didn't go to performing arts school with Miss Franks' grandmother, did you?
No, ma'am.
Now, I'd like to talk to you about the 9th of June 9th. In your statement, you mentioned seeing Carter Lucky with Jordan Franks on that night, correct?
Yes, ma'am.
You saw Franks and Lucky together at your party, correct?
Yes, ma'am, I did.
You even saw Franks and Lucky together at the Blue Diamond Cafe after the party, is that correct?
Yes.
And you mentioned all of this when Detective Mavis interviewed you?
I mentioned everything I knew about Jordan and Billy's rocky relationship.
Your Honor, I have no further questions.
Defense?
Your Honor, may my witness please be excused from the stand?
She may.
At this time, may I call Ari Couch to the stand?
Yes, Ari Couch, please approach the stand. Please raise your right hand. You solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and the rules of the mock trial competition?
I do.
You may proceed.
Good evening.
Good evening.
Please state your name and occupation for the court.
My name is Ari Couch, and I'm a certified jewelry appraiser for both the American and French Jewelers Associations.
Would you briefly describe your academic background?
I majored in archaeology at Oxford, where I completed the graduate gemologist program at the Gemological Institution of America, where I specialize in 15th and 16th century pieces.
And how long have you been a gemologist for?
At heart, all my life, but professionally 15 years.
And are you involved at the case at hand?
I am. I was requested to evaluate the lineage and value of a Shakespearean signet ring.
And did you have a chance to do so?
Yes, I examined the ring and the relevant documentation created by the Royal Academy of Arts.
Do you recognize Exhibit B?
Yes, it's an image of the signet ring I was requested to evaluate.
Is it a fair and accurate representation?
Yes, it is.
Your Honor, may the witness please approach the exhibit?
Yes, you may.
How did you evaluate this ring?
I compared the ring's characteristics to an early 1600s portrait on display at the Shakespearean Birthplace Trust, where the ring is clearly visible.
And did any of these characteristics match?
There are several matching features, including these intertwined tassels here, also known as a bowen, and the size and style of the letters WS, which would obviously stand for William Shakespeare.
And what have you uncovered about the known ownership of the ring?
Well, according to Shakespeare's last will and testament, he left the ring to his fellow actor John Hemmings. Hemmings then bestowed the ring to a distant relative, Henry Schaeffer. The ring was then passed down to the Schaeffer line, ultimately given to Cleo Schaeffer.
And given the lineage of the ring, what is your ultimate conclusion?
Given the matching characteristics and the relevant documented history, I can say that the ring is a genuine heirloom of William Shakespeare.
And given your experience as an appraiser, what value would you place on this ring?
Well, its material value would stand close to $770. Its connection to Shakespeare would dramatically increase that to $170,000 or £148,908, a little out of my price range.
Thank you, Ms. Couch. No further questions, Your Honor.
Thank you. Defense?
Good evening.
Good evening.
The style of the signet ring was common in the Elizabethan era, correct?
That is correct.
And that means that there are other rings from the Elizabethan era with a similar style, correct?
There are similar rings, but the engraved, there are some engraved distinct designs that would definitely,
You also know the initials WS were common in Shakespeare's time,
yes.
correct?
Correct.
And you know that the signet rings are used to seal documents?
That is correct.
But you know that no documents produced by Shakespeare were marked with the ring?
Well, there are no known documents, but Shakespeare could have easily produced used another ring that he had.
You used the 8 by 11 foot painting as proof that the signet ring belonged to Shakespeare, right?
I used that painting as a reference to compare the matching characteristics of the ring.
Don't you agree that people could have looked at the painting and created a replica ring?
That could be true.
So, couldn't the painting have possibly provided the necessary detail for a replication of a ring?
Yes.
You mentioned that John Hemmings was one of Shakespeare's contemporaries, right?
I did. I mentioned that he was a fellow actor of Shakespeare.
You mentioned the ring was discovered in 1769. That's over a century since Hemmings' death, isn't it?
That is correct.
In fact, that's a period of 139 years, right?
That is correct.
And there are no records of the ring's location from Hemmings' death to 1769.
Well, there are no known records of the ring's location.
So, there weren't any records of who had the ring between Hemmings' death and 1769.
There are no known records of that.
So, records of this ring are missing for over 3 generations.
That is correct.
The next written documents recording where this ring were, the ring was written 11 years later in 1780.
They were written by the Royal Academy of Arts 11 years later.
So, there's 150 years without any documentation regarding the ring's location or commission.
That is correct.
That's a century and a half. You cannot tell us where the ring had been or where it was, isn't it?
That is correct. I can't tell you. There are no known documents.
And the people who wrote the record acknowledge this?
Yes, they do.
The Royal Academy of Arts does mention this to you, but the ring others though, don't they?
They do mention that.
And this is the source you're relying on to make your conclusions?
That is the source I am relying on.
Your Honor, I have no further questions.
Thank you.
Oh, wait,
Dismiss it.
Your Honor, may I dismiss my witness from the stand?
Yes.
And at this time, the people would like to call Billy Scher to the stand.
Billy Scher, please approach the stand. Please raise your right hand. Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
You may proceed.
And for the convenience of the court, this witness's testimony can be found on page 30 of the case packet. Please state your name and occupation for the court.
Good evening. My name is Billy Scher, and I'm a professional actress with a degree in dramatic arts.
And as an actress, what, if any, recent productions have you been a part of?
I recently finished my run as the lead role in Macbeth at Sea for the Heart of the Ocean cruise ship. I'm lucky that my hour on the stage lasted for a great 3 years.
And what were your plans for after Macbeth at Sea?
I was cast as a lead role in an upcoming Broadway musical called Jefferson the Musical. I was just thrilled for the opportunity to take my career to the next level.
Now, Ms. Scher, is there anyone in the courtroom today whom you recognize from your time on the Heart of the Ocean?
Yes, the defendant Jordan Franks. They are seated behind the defense table with their hair up, wearing a navy suit and black boots.
Your Honor, I ask at this time that the record reflect that Ms. Scher has correctly identified the defendant, Jordan Franks.
The record reflects that.
And what connection, if any, do you have with the defendant?
Jordan and I were classmates and roommates for 3 years. We were actually set to work together again in Jefferson the Musical. When I found out I was cast as the lead, I also found out they were casting my understudy. Basically, it means if I perform for any reason, let's say injury, Jordan would step in.
And do you know how the defendant reacted to this casting decision?
I can't tell you how they felt, but I can definitely tell you how they reacted that night.
How so?
Well, immediately after our final performance, they accosted me backstage. They kept on talking about some line changes during the show, but I had no idea what they were talking about. There's a time and place for improv, but no one can improve upon Shakespeare.
And did this confrontation escalate?
Luckily, no. Auntie Cleo came by to remind us about the rap party happening that night. I hope they don't get Jordan to stop bothering me.
And what, if anything, of significance did you do before the rap party?
I went back to a shared cabin to put my signet ring away. I didn't want to wear it to the party and risk losing it. Normally, I put it in my safe, but I was in a hurry, so I put it in this box on my dresser.
Could you briefly describe this ring to us?
Of course. I believe that Shakespeare's original gold signet ring. Auntie Cleo gave it to me as a gift.
And do you have any idea about the value of this ring?
Well, she showed me some paperwork that said it had a pretty high value. It was such a thoughtful gift, and that's why I wanted to take good care of it.
And what, if anything of significance, happened at the wrap party?
Mainly, I was talking to my fellow castmates and avoiding Jordan. The casting situation felt awkward, and while I love drama on the stage, I don't love it in my personal life. I ended up leaving at around midnight.
And where did you go?
I went straight to my room.
What did you see when you got there?
I saw Jordan standing at my dresser, facing towards me, holding what looked like my ring box.
How did you react?
I screamed, "Give me back my ring."
And did they respond?
Yes, they lunged towards me and said, "How could you do this to me? You don't deserve the role or the ring. Get out of my way."
And did you get out of their way?
No, in an effort to keep them from stealing my prized possession, I blocked the door, and that's when they shoved me with what seemed like was all of their might. I fell to the ground, and I hit my right arm on the bed frame. Immediately after, I tried to get up, but I felt an intense pain in my arm.
And what happened right after you fell?
I saw Jordan run out of the room with the ring box in hand. As soon as I could, I called 911 and reported the violent robbery.
And how were you feeling at that point?
By the time the paramedics arrived, I was in a lot of pain, and they transported me to the local hospital. It was there where I received treatment and found out that I'd be in a cast for 12 to 16 weeks.
Good evening, Miss Scher.
Good evening.
Cleo Schaefer gifted you a signet ring, correct?
Yes, she did. It's such a thoughtful gift, and I'm so lucky that I have her in my life.
And you believe that this ring once belonged to William Shakespeare,
Yes,
right?
I did. According to some paperwork, she showed me that she gave me some authentication.
But you never mentioned doing any research yourself on the ring's ownership, do you?
No, I trust Auntie Cleo with everything, and I didn't feel any need to do my own research.
Thank you. Now let's talk about the night of June 9th, 2022. When you opened the door to your cabin, Franks was standing on the other side of the room in front of your dresser, correct?
Yes, they were.
The lights in the room were off, correct?
They were, but I could see through the lights in the hall.
And then, when you proceeded to scream at Miss Franks, she appeared startled, didn't she?
Yeah, I think we were both a little startled.
But instead of getting out of her way, you purposefully blocked Miss Franks' way to the door.
I was shocked she was trying to steal my prized possession, so I did try and keep her from taking it.
Is that a yes?
Yes, it is.
Then you hit the bed frame, right?
Yes, after she shoved me, I fell and hit my right arm on the bed.
You described the events of that night as causing a shock, correct?
Yeah, you could say that.
After everything that happened so fast?
It did all happen in one night, if that's what you're asking.
You weren't paying attention to Carter Lucky, were you?
No, I didn't feel any need to. We're not that close. We're not...
Is that a yes?
Yes.
You don't know how long Carter Lucky was there, do you?
No, I only noticed it later, after I fell and hit my arm.
You don't know where Carter Lucky was before this, right?
No, I didn't feel any need to. Like I said, we're not close, and I didn't have any reason to know where they were.
Nor do you know where Carter Lucky went after.
No, like I said, I had no reason to know where they were.
And you didn't see where she was, because it was only after you got her your shock that you even spotted her. Is that correct?
After I fell, I did see her in the doorway, yes.
Thank you. Your Honor, I have no further questions.
At this time, we ask that our witness please be dismissed from the stand, and the prosecution rest their case.
Wait, what do I say? Call up. What do I say? Call up.
Arrested, defense, have any witnesses they would like to call to the stand?
Yes, we would like to call up Jade Marquez.
Jade Marquez, please approach the stand. Please raise your right hand. You solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition. You may proceed.
Good evening.
Good evening.
Please state your name and occupation for the court.
Good evening. My name is Jade Marquez, and I'm an appraiser of the finest jewelry, as well as the owner of Marquez's Auction House and appraisal business.
How did you become an appraiser?
Early on in my career, I interned at an old auction house called MacDuff's. Later, I became their leading expert in historical appraisals and museum partnerships. For 24 years, I worked my way up to Senior Vice President of Jewelry, a role I held for 6 years, and then I moved on to found my own appraisal business and auction house.
If you add all that up, how long have you been working in the field?
will not reveal my age, but it's been over 40 years since I started working in the industry.
What, if any, involvement do you have with the case at hand?
Well, I was asked to examine the signet ring and its provenance papers to determine its original ownership and worth.
Are you familiar with Ari Couch's written statements regarding the signet ring?
Yes, I am.
What is your expert opinion on Miss Couch's appraisal?
Well, I would have to disagree. Miss Couch relies on assumptions and unsubstantiated conclusions. I do agree that the ring could be from the 15th and 16th centuries, but there isn't enough evidence to be able to definitively say that the ring is Shakespeare's.
What is your process of examination for a piece like this?
Well, there are 5 key things to look for: stamps, age, weight, stones, and substance, or what I like to call sauce. It's a skill that takes decades to refine, but those are the 5 key factors.
Were some of these categories more useful than others in this case?
Well, I first visually examined the ring and found that there were no stamps or maker's marks. I also found that the ring comprised of 14 grams of gold.
Were there any significant markings on the ring?
The initials W and S were engraved on the ring's face, which is consistent with the Elizabethan style. But it's important to note that a counterfeiter could have easily copied these markings. Also, Shakespeare never marked or sealed any known documents we could have compared it with.
What does this mean for you when trying to determine the ring's age?
It doesn't mean anything. One has to look at historical documents like the provenance papers. It doesn't mean anything. A ring today could be made with the exact same styles and the exact same style and the exact same markings. That's why you have to look at historical documents like the provenance papers, which I did.
Can you explain what the provenance papers are?
Provenance papers are the documentation that show who may have commissioned the ring, who may have owned it, and who may have exhibited it.
Who provided the provenance papers for the ring?
In this case, the Royal Academy of Arts provided the provenance papers. But it's important to note that these provenance papers were made after the ring was rediscovered in 1769, which is after the Elizabethan era.
What is your conclusion about the value of the ring?
Well, since 1 gram of gold is estimated to be around $55.09, and since this ring comprised of 14 grams of gold, then the metal weight price would be $771.26.
Would any historical value impact the value of the ring?
Look, it's as simple as this. The ring disappeared from history for more than 150 years. And since it lacks direct connection to Shakespeare, we can't definitively say that it is his. And the age wouldn't inflate the value because it wasn't well maintained. So it's worth its weight in gold. $771, not much more.
Your Honor, I have no further questions.
Good evening, Ms. Marquez.
Good evening.
You state that without a historical connection, this ring is worth $771.26. Is that so?
Yes, that is correct.
And you state that if this ring has a historical connection to the 1600s, it wouldn't be worth much more than a gold ring created today.
Yes. Since it lacks direct connection with Shakespeare, the price would not inflate.
But not much more is still more.
This inflation, if there is any, would be very little, so much so that it's not necessary to include.
And you never stated by how much this ring would increase if it did have a historical connection.
No, I did not.
And you acknowledge that this ring may date back to the 15th and 16th century. Is that so?
Yes, that is correct. It may date back to those times.
And its characteristics are that of the Elizabethan era?
Yes, they are, but to be fair, a counterfeiter could have easily copied these styles.
Take, for example, the lettering?
Yes, the initials W and S were engraved on the ring's
and
face.
The bowen?
Yes, that was also engraved, but a counterfeiter could have easily copied it.
Now, moving on to your involvement in this case, you heard about this ring from your previous connections.
Yes. In the jewelry industry, word does travel fast.
And you heard that not everyone who saw the ring believed it belonged to Shakespeare.
A few of my colleagues were unsure about its lineage.
And this was before you saw the ring?
Like I said before, word in the jewelry industry does travel fast.
And you previously knew the ring was displayed at the Shakespeare Birthplace Trust?
Yes, I did hear that they displayed it, but they did acknowledge the controversy over the ring on their website.
A museum that specifically displays items affiliated with Shakespeare?
Again, they did acknowledge the controversy, but yes.
But they did still display the ring, did they not?
Yes, they did.
Thank you, Ms. Marquez. No further questions, Your Honor.
The defense likes to excuse their witness.
May our witness be released from the stand?
Yes.
The defense calls Ezra Weintraub to the stand.
Ezra Weintraub, please proceed. Please raise your right hand. You solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock-trial competition? I do. You may proceed.
For the court's convenience, this witness testimony can be found on page 46 of the case packet. Good evening.
Good
Please
evening.
state your name and occupation for the court.
My name is Ezra Weintraub, and I'm the head of security on the Heart of Oceans cruise ship, and I've been working there for 8 years.
What do you do as head of security?
My job entails key card usage, guest Wi-Fi, and monitoring security cameras.
Were you working on the night of June 9th, 2022?
Yes, I was working a 12-hour shift that started at 7 p.m. on June 9th and ended the following day at 7 a.m. I'm very used to the long night shifts.
Did you speak to anyone in that time period?
Yes, I spoke to Detective Mavis where they asked for the security camera footage from 9 p.m. to 3 a.m.
What did you tell the detective?
I told the detective that I unfortunately could not give her the security camera footage because it wiped itself at 3 a.m. every single day, and by the time they came to me, the footage had already erased itself.
Did you tell the detective anything else?
Yes, I told the detective that the changing rooms are open 24/7 so the staff can enter in and out whenever they need to, as well as there's no security cameras in the dressing rooms due to privacy reasons, and that what I saw during the shift on June 9th, as well as that I monitor 18 different cameras.
What exactly did you see on the cameras?
I saw Carter Lucky and Jordan Franks enter in the camera, but I do not recall them entering at different times. I don't recall what time they entered.
Thank you. Your Honor, I have no further questions.
Your Honor, may I conduct cross-examination? Good evening, Ms. Weintraub. During your conversation with Detective Mavis, she asked you for the footage of the night between 11 p.m. and 3 a.m., correct?
Yes.
Were you able to provide her with that footage?
I was not.
Why were you not able to provide her with that footage?
Because the security camera footage erases itself at 3 a.m. every single day.
And
by the time she came to me, the footage had already erased itself.
so, did you see anybody go into the dressing room at any point that evening?
Yes, I saw several cast members enter in and out after 9 p.m., but that is when the show did end. But as I said earlier, I did see.
Did you see Jordan Franks enter the dressing room at that point?
Yes.
Okay. Moving on, you did, under your care, several room locks malfunctioned, correct?
Yes.
So you had to give the keys to multiple cast members?
Yes, that is correct.
And of the following rooms, Miss Scher and Miss Frank's room had malfunctioned as well, correct?
Yes.
So that meant that you gave the keys to that room to them and only them?
Yes. That is
So to clarify, only Miss Scher and Miss Franks would have access to the room?
Yes. As well as Detective Mavis. When she.
Well, Detective Mavis at the time was not involved, so she wouldn't have had access.
Yes, she later had access.
Okay, thank you for clarifying. Thank you, Your Honor. No further questions at this time.
Your Honor, may I
Your Honor, shall be released from the stand.
Yes, you may.
The defense calls Carter Lucky to the stand.
Carter Lucky, please put your stand. Please raise your right hand. Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the law of the Constitution?
Good evening.
Good evening.
Please state your name and occupation.
My name is Carter Lucky, and I'm an actress who worked on the production of Macbeth at Sea.
Did you have any potential job prospects after Heart of the Ocean?
Not really, although I did audition role after role, but didn't get chosen, which really sucks because I don't want to move in with my parents again.
Do you know Jordan Franks?
I do. She made me love acting.
What was your relationship with her like?
She was a friend and a mentor. The Rosencrantz and my Guildenstern.
Are you familiar with Billy Schur?
Yes, they were also in the cast.
How do you know them?
Mainly through all the drama they were causing, acting all manipulative and dramatic. And I'm so jealous that they have so many connections to castings and managements.
Before the night in question, were you aware of any conflict between Miss Schur and Miss Franks?
Not that I knew of, although Miss Jordan told me that she was talking to Billy and told Billy to break a leg, which is just a term of endearment for an actor.
When did you leave the party?
Around after Billy did, which was midnight.
And after you left, where did you go next?
I went to look for Jordan because I hadn't seen her in a while. So I went to her cabin and I heard some yelling. So I stepped in the doorway and I saw the two of them arguing.
What happened next?
To me, it looked like Billy ran into Jordan, fell on the ground, and bumped their arm on the wooden bed frame.
Did you see Miss Franks react to this?
Yeah, Jordan seemed a bit flustered about it. I told her I'd meet her in the Blue Diamond Cafe after.
And where did you go after that?
I got a bit sidetracked, but I got to the cafe about 30 minutes later.
Did you speak to Miss Franks at the Blue Diamond Cafe?
Yes, I talked to her for about 30 minutes and then left.
And before returning to your room, did you go anywhere else?
I stopped by the cast dressing room to see if anyone was in there.
And all of this that you've told me, did you also state in your statement to Detective Mavis?
I did.
No further questions. Thank you, Your Honor.
Your Honor, may I conduct a cross-examination, please?
Yes.
You described Franks as a mentor, right?
Yes.
And Franks also said that Schur's ring was worth a crazy amount of money, right?
Correct.
Didn't they also tell you that the ring was the last thing Schur's ego needed?
They did.
Turning to what happened that night, didn't you hear yelling from inside the cabin?
Yes, I did.
And what did you do in response?
Well, I was just watching from the doorway.
So even though you saw an argument occur between the both of them, you did nothing before, during, and after that argument?
No.
So you claim that you saw Schur ran into Franks, bumped their arm on the bed frame, and fall to the ground.
Yes.
But the lights were not on inside the cabin.
No, they were not.
So how could you know what you've seen?
Well, the lights in the hallway were on, but I could barely see what was going on.
So it couldn't be certain that Schur actually ran into Franks and hit their arm on the bed frame and fell, right?
Well, yes.
Miss Lucky, after Franks left, you saw Schur on the ground in substantial pain, and you did nothing to help them.
I did not do anything.
And then you saw Jordan Franks inside the Blue Diamond Cafe 30 minutes later.
Yes.
You didn't know where they were during that time, right?
No.
Thank you, Miss Lucky. So, also, by the way,
You didn't steal the ring, did you?
No, I did not.
Thank you, Your Honor. I have no further questions at this time.
May my witness be released from the stand?
Yes, she may.
The defense calls Jordan Franks to the stand.
Lord Franks, please first stand. Please raise your right hand. You solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the law of the Constitution? I do. You may proceed.
For the court's convenience, this witness testimony can be found on pages 39 through 41 of the case packet. Good evening. Please state your name and occupation for the court.
My name is Jordan Franks, professional actor. I recently finished the job in the production of Macbeth at Sea on the cruise ship part of the ocean.
And how long did you work on the ship?
I've been working on it since 2018, which would make it about 4 years now, just enough time to get to know my castmates.
Do you get along with your castmates?
I get along with most of them pretty well, especially Carter Lucky. However, Billy Sure and I have had our fair share of differences.
Can you elaborate on your relationship with Billy Sure?
I respect her as an actor, of course, but I noticed some what I perceived as special treatment towards the end of our show, which really frustrated me considering the effort I put into the show.
Why were you frustrated with her?
Prior to our closing show, I found out that I was to be Sure's understudy in Jefferson the Musical. In addition to this, Sure randomly changed one of my lines and really embarrassed me on stage during our last show.
Did you mention your frustrations to Miss Sure?
Hesitantly, yes, but she didn't really seem to care. That was when Cleo Schaefer came in to inform us of the rap party.
And did you attend this rap party?
Yes, I wanted to congratulate and converse with fellow castmates, but I left around 11 p.m.
Where did you go after you left the party?
Straight to my cabin. I was so annoyed about all the drama of that day.
Did you go anywhere else that night?
I was planning to go to the Blue Diamond Cafe, so I picked up my phone on the dresser near my bed. That's when Sure walked in.
Did you speak to Billy Sure when she entered the room?
Yes. I don't recall much except her tone. She just kept going on and on about her role and her ring. I just wanted to go to the cafe and decompress.
And what happened next?
On my way out, I unintentionally bumped into Sure. This was a complete accident, as I was trying to go to the cafe.
Did you notice anyone else in the area?
I briefly noticed Carter Lucky standing in the doorway, but I'm unsure of how long they were there for.
And where did you go after such a dramatic event?
I went where I was trying to go the whole time, the Blue Diamond.
What happened while you were at the cafe?
Not much, honestly. I was just chilling and scrolling through my phone for about a half hour. Then Carter Lucky arrived and we talked for about a half hour. After she left, I stayed there the rest.
Was in the 30-minute time period before she met up with you?
Honestly, no. I had not last seen her since I spotted her outside of my room.
What happened after Carter Lucky left?
After she left, Detective Mavis came up to question me about the ring.
Can you tell us a bit more about this interaction?
They showed me Sure's ring box and asked if I recognized it, but then brought me to my cabin for questioning and proceeded to accuse me of stealing Sure's Shakespeare ring, which I definitely did not do.
Can you briefly elaborate on the ring you mentioned?
It's a signet ring that I supposedly belonged to William Shakespeare. As an avid Shakespeare fan, I was intrigued by it and curious about whether or not it actually was one of Shakespeare's.
Did you ever research the ring's history?
I did, in fact. I even wrote down a number for an auction house in New York, though I never called. I was just curious.
Where did you keep this information?
I kept it in a safe Detective Mavis kept pressuring me to open.
Did you happen to see the signet ring in your cabin that night?
No, I did not.
Are you aware that the ring was found in your costume pocket?
Yes, yet when it's thrown back to the dressing room, it's fair game. Someone could put it in the pocket themselves, or found it when they were wearing it.
Do you know how it got there?
Not a clue. The show was over and I wasn't planning on returning to the dressing room. I didn't go anywhere else that night except the cabin and the cafe.
Miss Franks, did you intentionally harm Billy Sure?
Of course not. I would never intentionally harm anyone, especially not a colleague.
And did you steal Billy Sure's signet ring?
No, I did not. Granted, I was interested in the Shakespearean aspect of it, but I overall respect Sure. I would never dream of doing such a thing.
Thank you, Miss Franks. Your Honor, I have no further questions at this time.
Good evening.
Good evening.
You're an actor, right?
I consider myself that, yes.
you make a living off of being in stage productions?
Yes.
And one production you made a living off of was Macbeth at Sea, correct?
Correct.
And you co-starred with Miss Sher in the recent production of Macbeth at Sea, right?
Yes, I did.
And when this production came to an end, so did your paycheck, correct?
Technically, yeah.
But you got a new position as the under Miss Sher in Jefferson the Musical, right?
Correct.
As an understudy, you wouldn't be performing with Miss Sher, correct?
No.
And what I mean by that is that you would be unable to perform unless Miss Sher wasn't able to, right?
That is the role of an understudy, yes.
And one reason she would be unable to perform is due to injury, correct?
Injury among many other reasons that would keep her from performing.
And you would agree with me that Miss Sher got your dream lead role, correct?
It was my dream, yeah.
And you were frustrated by this casting decision, weren't you?
Slightly.
You were frustrated because with her taking up the spot, you wouldn't get to star in your dream lead role, right?
Yes, but I was still happy for Billy. She'd worked hard for that.
And you expressed your frustration to her after the final performance of Macbeth at Sea, right?
Yes.
You accused her of changing some lines in the show, right?
Yes, I noticed that.
And you were very upset with her, correct?
Yes.
And just to clarify, this is the same day as you found out you were Miss Sher's understudy.
Yes, it was.
And later that day you went to a wrap party, right?
Yes, I did.
But you left the wrap party early because you were sick of being around Miss Sher, right?
And I was very tired. It's been a long day with a lot of acting.
So you went to your room where you knew Miss Sher wouldn't be, correct?
Correct. She was at the wrap party.
And after an hour, after your frustrating day with Miss Sher, you went to Miss Sher's dresser to pick up what you claimed to be your phone.
Yes, I needed my phone to go down to the cafe.
And that's when Miss Sher entered the room, right?
Yes.
And when she started bragging about the ring as you claim, you became very frustrated with her, didn't you?
Yes, I was already tired of her constant attitude. I just needed a break from it.
And in leaving the room, you collided with Miss Sher, right?
Yes, I was going out, she was coming in. It was a completely accidental collision, but it was bound to happen.
But you saw Miss Sher fall to the ground, right?
Yes.
And you heard Miss Sher scream, correct?
I thought she was being dramatic, and my being there would inflict on her.
Is that a yes or a no?
Yeah.
And you still left the room without checking on her, isn't that right?
Yes, again, I thought she was being dramatic and was trying to get attention or something.
Now, Miss Franks, isn't it true that you are a huge Shakespeare fan?
Yes.
You were familiar with Miss Sher's ring, right?
So was everyone on the boat.
In fact, you were interested in the ring, right?
Yes, I thought people would be.
And you wanted to find out about its authenticity, correct?
Correct.
Now, directing your attention to Exhibit A, this is a photograph of the note you wrote the detective found in your safe, correct?
Yes, it was.
And the phone number on this note is the number for a New York auction house, right?
That is correct.
And you were planning to move to New York where this auction house was the next day, correct?
Yes, but that was something I'd already been planning for a while.
And Ms. Franks, isn't it true that you thought something like Miss Sher's ring would cause quite a stir at an auction house?
Yes, it would.
Thank you, Ms. Franks. Your Honor, I have no further questions. Did I call her Miss Sher? I think I did that.
Your Honor, may Jordan Franks be released from the stand?
Did I call her Miss Sher at one point? I think I did.
Both sides have rested their case. I believe it's time for the argument. So, prosecution, if you'd like to receive yours.
Yes. Imagine you are an actor who recently got the lead role you had been waiting for your whole life, but then it got snatched away by a person who couldn't control their emotions. For Billy Sher, this scenario was not just an imagination, but a grim reality because of the defendant, Jordan Franks. Jordan Franks, a person prone to envy, was deeply unsatisfied with their position in life. Instead of working hard, they blamed their shortcomings on others. To the defendant, Miss Sher was not the talented actress she worked to become, but she and her Shakespearean signet ring were symbols of the perceived injustices that Jordan Franks fabricated. So the embarrassment on their last show and the loss of their lead role were the last straws for the defendant. And when they were presented with an empty cabin, Miss Sher's ring unusually left outside the safe and an hour to ensure the risk was worth it, the night of June 9th became one where the defendant envy met opportunity. Honor, the people ask that you find Jordan Franks guilty of battery causing serious bodily harm and robbery. If you find the defendant not guilty of battery, we ask that you deem them guilty of grand theft or lesser offense of petty theft. In the CalCrim instructions presented by Ms. Blanchard, are numerous and overlapping, but they all boil down to 3 questions. 1, did the defendant take the ring from Ms. Scher without her consent? 2, was the ring taken worth more than $950? And 3, did the defendant willfully use force to take the ring from Ms. Scher? Addressing the first question, Ms. Scher testified to seeing the defendant ring box in hand leaving their cabin, and Ms. Schaefer testified to how she saw the defendant throw something away in the same trash can where the detective later found the ring box. They also found the ring box not just lying around anywhere, but in the dressing room inside the defendant's own coat pocket. Now, opposing counsel will argue that all these instances line up perfectly to cast doubt on the people's case, but they seem to have disregarded one fact. That is that said doubt must not simply just exist, but also be reasonable, and their narrative is anything but that. Having determined that the ring was taken without Ms. Scher's consent, a second question arises. Was the ring taken worth more than $950? If a stolen article is worth more than $950, it is considered to be grand theft. In addition, the people's expert witness provided a multitude of documents and evidence, including a portrait of Shakespeare, ring on hand, and a multitude of documents confirming the connection to this to Shakespeare. The defense cannot rebut the fact that jurors seem to have owned the same ring, and they could definitively tell the court by how much more the ring would be worth than $950 due to its connection to the 1600s. The people have proved that the defendant took the ring against Ms. Scher's will, leading us to our third and final question. Did the defendant willfully use force to take the ring from Ms. Scher? The defense will argue that any harm caused was completely accidental and unintentional, but it is quite true what clearly happened. Ms. Scher testified to how the defendant became enraged when she confronted them. Their envy overtook their senses, causing them to yell at Ms. Scher. In an attempt to salvage her most prized possession, Ms. Scher blocked the doorway, but the defendant violently shoved Ms. Scher into the bed frame. That force, according to stipulation 17, not only broke Ms. Scher's arm in one, but places. Tonight, the defense wants you to believe that Ms. Franks is not guilty and that Ms. Scher was simply being dramatic. The people have proven how the defendant had every reason to, and eventually did, seize the opportunity to take from Ms. Scher what was not theirs. For these reasons, the people ask that you find the defendant guilty of all charges. Thank you, Your Honor.
Closing argument for the defense.
Tonight, the defense has showed how the people have rushed to judgment and sped past the truth. Their case is built not on solid evidence, but on evidence left unexplored and unexplained. From the second Billy Scher stepped into their cabin, the moment Detective Mavis boarded that ship, they were quick to assume, slow to assess, and failed to conceive any other possibility that wasn't the first one that came to their mind. The people claim that it was the night where envy met opportunity, yet Detective Mavis failed to investigate all opportunity. Detective Mavis immediately established Jordan Franks as the only suspect and barely looked into other suspects, such as Carter Lucky. It began with Ms. Scher and her judgments. Already frustrated with Ms. Franks, Ms. Scher sees Ms. Franks in their cabin holding something and rushes to a conclusion. It was dark, it was fast, And Detective Mavis took this as the sole truth rather than investigating impartially. With how hastily Detective Mavis has taken this investigation, it wonders how much actually done adequately. Even after learning that Carter Lucky was present at the cabin, at the cafe, the dressing room, and that there was a 30-minute window of time in which nobody knew where she was, Detective Mavis remained laser-focused on Jordan Franks. 4,000 passengers, 1,200 crew, and a specific viable suspect with a similarly alleged motive, yet Detective Mavis investigated none of them. All of this provides reasonable doubt to the charge of larceny. The question then, the difference between grand and petty larceny, is whether the people can establish beyond a reasonable doubt that this ring did in fact belong to William Shakespeare. Under Calcrum 1860, the court must consider the information in which it is being relied upon. Ari Couch stated that the ring style was very common for the Elizabethan era, and the simple truth is that all paperwork and documentation for this ring was made 150 years after Shakespeare's death. During that time in which we have no idea how many replicas were made or where this particular ring has been. Ari Couch assumes the ring is Shakespeare's. They want to believe the ring is Shakespeare's, but they are rushing to judgment and ignoring the enormous gaps in history and the lack of evidence proving so. As Jade Marquez said, this ring is worth its weight in gold, not much more. And under Penal Code Section 488, that's petty theft at worst. Moving on to the charge of battery. Under Calcrum 925, the people had to establish that Miss Franks willfully harmed Miss Scher and that Miss Scher sustained serious injury from it. Miss Scher is the only eyewitness to allege that Miss Franks pushed her. Who in their own witness statement admits to being in immense pain and that the events all happened so fast. In shock, in pain, Miss Scher's testimony should not be taken at face value. Miss Lucky, in neither shock nor pain, saw the event for what it was, an accident. With this pain of a broken arm in mind, we must ask how clearly Miss Scher remembers the events that happened that night. Once again, Detective Mavis took this testimony and decided neither to corroborate or challenge it. With all of this in mind, the people have failed to prove beyond a reasonable doubt that Miss Franks willfully harmed Miss Scher. Finally, the charge of alleged robbery. Under Calcrum 1600, in order to meet the burden of proof for robbery, the people have to satisfy the requirements of both larceny and battery. We can't say the defendant used force or fear because the conflict was an accident. We can't say who went into Miss Scher's room that night and took their ring without consent because Miss Scher's claims were made in a frenzy, and Detective Mavis decided neither to confirm those claims or to find any alternative theories or suspects. Tonight, the prosecution has failed to prove beyond a reasonable doubt that Jordan Franks committed any of the crimes she's charged with here tonight. There are too many pieces of this puzzle that the prosecution has glossed over. Miss Franks may have been at the scene, but so was Miss Lucky. Miss Franks had time and was at the dressing room, but so was Miss Lucky. Miss Franks had motive, but so did Miss Lucky, if not a stronger one. Yet to what extent did Detective Mavis investigate Miss Lucky? One interview, one statement that passes as thorough in their mind, and that's their claim to due diligence. From the second Detective Mavis arrived on the ship, they simply took Miss Scher's word and for 7 hours followed along the exact story that Miss Scher gave them. That is not due diligence, that is not a proper procedure, and it's not beyond a reasonable doubt. For these reasons, we ask that you find Jordan Franks not guilty on all charges. Thank you, Your Honor.
Thank you, defense. So now I will allow each side a brief rebuttal. But just know that because we're not keeping time this evening, I may cut you off if you go too long just to keep things moving. But the people would like to rebut. They may.
Thank you, Your Honor. Addressing the defense's first argument, Detective Mavis only investigated the people they thought were important on the ship. They couldn't go around the whole ship and investigate every single person and get a testimony from them. That would simply take too long and would be unreasonable. Moving on, the portrait of Shakespeare clearly showed a ring on Shakespeare's hand, which seems to be Exhibit B. And as Ms. Couch has already stated, she has brought in evidence of documents that prove this historical connection. Once again, Ms. Scher testified to how she saw the defendant, Jordan Franks, leave the room, ring box in hand. And Ms. Schaefer also testified to how she saw the defendant also throw something away in the same trash can where the detective later found that ring box. At the same time, though Lucky may only have one testimony, one meeting, they were biased. They are friends with the defendant, Jordan Franks, so obviously they would try to help the defendant and make him seem not guilty. Thank you, Your Honor.
Thank you. Defense?
Did Detective Mavis have time to investigate 5,200 people? No, of course not. But the defendant's best friend with a similar motive, who was present at the cabin, the cafe, the dressing room, and had a similarly alleged motive, was only given one interview. Only one statement was given. Maybe not 5,200 people, but one other person with a very, very likely chance wouldn't have been that much fun. And the ring, yes, while our couch does believe, they are rushing to judgment. And they did state it was very common for the Elizabethan era. And the point of the matter is that there are too many holes in this story to truly be able to confirm beyond a reasonable doubt that Jordan Franks pushed Ms. Scher and stole the ring. Thank you.
So, time to give my verdict. Ms. Franks, if you and your counsel can please rise for my verdict. All right, so I'd just like to say both sides argued extremely well. I thought there was a multitude of amazing points that were brought up. Some very interesting ones that I think raised a lot of perhaps doubts, and in other cases it confirmed things, that sort of thing. But after deliberating and taking into account all of the evidence offered, as well as maybe some evidence that was not offered, I do believe that Ms. Franks is guilty of robbery and battery. However, I do not believe that the ring she stole belonged to Shakespeare. So in the case where I would not have ruled it such, it would have been petty larceny. So yes, I don't know what happens next. I guess Ms. Franks goes to jail. But so we'll see her in a few years. What? Oh, okay. But yeah, you guys can be seated. Before I kick it over to Mr. Tomczak, I just want to say how proud of you guys I am, because I've watched you guys since August when you all came in, and you guys have just like progressed so much, and like especially you guys are amazing. Especially I know this is a lot of your guys' like first or second years, so I'm just really impressed with all of the work that you've done and all the hard work you've put in. I mean, it's basically been like probably 6 months, I don't know, since you started doing this. So you guys have been dedicated and you've worked so hard, and I can really see it tonight and in all of our practices and all the other times, but especially tonight. So great job, everyone.